education, and positive outcomes for our community. Thank you. At this time, if you would like to come up, again, we'll give 5 minutes. We just ask that you come up so you can be heard at the podium, so people at home can hear you on our Facebook Live. And just as you come up, you come on up, sir. Just state your name for the record, and that's when your time will start, and we will begin.
My name is Tim Bennett. Esteemed board members, I would like to address you about an issue that has been going on in this county for quite some time. On the door of the south entrance to the Walker County Courthouse is a sign which lists numerous items which are forbidden to be brought into the courthouse building. This particular sign was replaced in August of 2023, so I don't know how long it's been there. This sign was purchased by the county at a cost of $47.98. The sign is deceptive and misleading on its face and in part unconstitutional. The sign lists a Georgia statute stating that it is illegal to bring weapons, cameras, cell phones, and recording devices into the courthouse building. The statute cited on the door is OCGA 161126 or 126. Strangely enough, the words courthouse, cell phone, camera, or recording device is not mentioned in that statute at all. Not even once. The words courthouse is mentioned in OCGA 1611-127. However, there is no reference to cameras, cell phones, recording devices, or anything relating to it. Inside the courthouse, the guards will tell you that the admonishment for bringing in cell phones, cameras, and recording devices is a judicial order given by the Chief Superior Court judge, but no one knows where a copy of this order is. And the reason it can't be found is most likely it doesn't exist. I would hope that none of the Superior Court judges are ignorant enough to sign an order which is contrary to the Constitution. The prohibition of cell phones, cameras, and recording equipment is capricious in nature, arbitrary in application, and discriminatory in execution. All the employees of the building are permitted to bring in their cell phones, as are all attorneys and their staff. If cell phones are forbidden from the building, they should be forbidden for everyone, not just the unwashed masses. The truth of the matter, the prohibition of cell phones, cameras, and recording devices is part and parcel of the Sheriff's Comprehensive Safety Plan, as authorized under OCGA 151610A10. and USCR 45A. The plan is funded by Walker County and executed by the Sheriff's Department. The plan is restricted from being seen by a public records request. However, it must be made available for you council members should you request it. As the plan is currently implemented, it violates the First Amendment of the United States Constitution and Section 1, Paragraph 5 of the Constitution of the State of Georgia. As a refresher, the First Amendment reads, Congress shall make no law respecting an establishment of religion or the free exercise thereof, or abridging the freedom of speech or the press, or the right of the people to peaceably assemble and to petition the government for redress of grievances. And the Georgia Constitution, under paragraph 5, says, no law shall be passed to curtail the freedom of speech or press. Every person may speak, write, and publish sentiments on all subjects, but shall be subject to the abuse of that liberty, shall be responsible for abuse of that liberty. And under paragraph 7 of the Georgia Constitution, it says all citizens of the United States resident in this state are hereby declared citizens of this state, and it shall be the duty of the General Assembly to enact laws as will protect them in the full enjoyment of the rights, privileges, and immunities due to such citizenship. Now, the courthouse is a mixed-use building containing the offices of the county clerk and superior courts, among others. The Supreme Court has established that it is the right of every citizen to record their public officials in the commission of their public duties as a means for documentation, transparency, and accountability. And under Smith v. City of Cumming, it was ruled by the 11th Circuit Court that the First Amendment protects the right to gather information about what public officials do on public property, and specifically a right to record matters of public interest. And the Supreme Court of Georgia has adopted the Uniform Superior Court Rule 22 regarding recording devices in courtrooms and adjacent spaces. However, nowhere in Rule 22 does it require encompassing the entire courthouse building. Rule 22 only applies to courtrooms, not courthouses. And by obeying this unconstitutional judicial order or misleading Georgia statute, court guards or officers whom are employed by the Walker County Sheriff's Department become criminally liable. 18 U.S.C. 242 makes deprivation of constitutionally guaranteed rights under the color of law a federal misdemeanor. The conspiracy of two or more people to deprive rights under federal law automatically changes it to a felony under 18 U.S.C. 241. It also opens up all parties involved, which includes the county itself, to an 18 U.S.C. 1983 federal civil lawsuit in which none of the parties involved would be granted qualified immunity. Further, the sworn public officers are in violation of OCGA 1610-1, violation of oath by a public official.
Excuse me, so let me interrupt you. Unfortunately, your time has expired. I'll let you go over some.
Okay.
If you would like to provide that document to the
Actually,
county attorney, or can send it to us either way.
It is currently in your USPS mail.
Okay, thank you, sir, very
Yes,
much.
sir.
We'll have our county attorney look into those concerns that you.
Thank you for the information.
Yes, sir, and thank you for the time.
Sure, sir, very good.
Ms. King, we just asked you.
I understand. No problem.
Yes, sir.
Okay, yes, anyone else like to speak tonight? Yes, sir.
The email is a public record, it's supposed to begin